A U.S. district judge in Kansas has just ruled that machine guns are common use firearms and protected arms under the Second Amendment in a decision I don't think anyone saw coming. Keep watching for the details. Hello everyone and welcome back to the channel. This case centers around defendant Tamori Morgan, who was charged with 2 counts of possessing a machine gun, particularly an Anderson manufacturing model AM-15 with a Glock switch. Morgan moved to get the case dismissed on basis of Second Amendment rights and Bruin. The government argued that machine guns are not protected arms and lost. Now, I'm going to give you all the details on the decision, but with the disclaimer not to get too excited. Mark over at 4 Boxes Diner thinks that ultimately this will be appealed and overturned, and I think he's likely right, as courts have upheld machine gun bans before. But who knows? Judge Brooms, a Trump appointee, did reach a logical decision under Bruin, so anything's possible, I guess. So let's go through it. Here are the key takeaways. First, the judge argued that by definition, machine guns are considered arms. In his opinion, he cited the part of Heller where it said that the Second Amendment extends to all bearable arms, even if those arms weren't around at the time of the Second Amendment. Though, from my history videos, we do know that there were plenty of multi-shot advanced weapons at the time. He also points out that to bear arms means to possess, and machine guns are guns that people can possess, and therefore are protected under the Second Amendment. This might sound pretty obvious, but is actually really significant coming from a court. Second big takeaway is that Brooms argued that because machine guns are protected arms, the burden falls to the government to prove that the ban on machine guns is consistent with historical tradition under Bruin. Here he said that the government's definition of machine gun could even count a full auto stun gun or BB gun, which would be kind of hilarious, all the way up to an air cannon. From the way that he wrote this in his opinion, I am guessing that that was in the government's argument because he said that that example actually hurt their case. Surprise, surprise. As a machine gun is clearly not an air cannon, is a bearable arm, and thus the government has to, again, prove that every possible iteration of their definition is constitutional to be banned. I love it when their mental gymnastics get used against them. You don't see it too often. The government argued that courts have allowed them to regulate particularly dangerous and unusual guns, and for some reason that phrase always makes me think of that Cyndi Lauper interview where she said, "Oh, who is this girl and why is she so strange and unusual?" But that is neither here nor there. The government argued that they are able to regulate particularly dangerous and unusual guns to the point of banning them, again arguing that these dangerous and unusual guns are not protected. For this, they cited Miller and Heller. Brooms argued that most of Miller was devoted to proving that the Second Amendment permitted, and at times even required, citizens to bear military arms. When the court ruled against the guy with a sawed-off shotgun in the case, it was under the argument that a sawed-off shotgun wouldn't be useful for military service and was therefore not protected. Now, Broom says that machine guns could be useful in a military setting, but that Heller showed people can possess or carry guns without malicious status, and thus people should be allowed to own and carry machine guns under Bruin. Now, before I get to the third big takeaway here and the government's arguments, here is a word about today's sponsor, Vanish Holsters, the most comfortable holster that you have ever worn, guaranteed. The number one concealed carry mistake is not actually carrying because your holster is uncomfortable or spending tons of money on different holsters that you never use. I know because I have done it. That is where Vanish comes in because your gun won't help you if it's sitting at home. Now, this holster fits 99% of modern handguns, accommodates 2 spare magazines, minimizes printing, and has 2 different size options on their fully adjustable belt, making sure that everybody can get the perfect fit, all while being so lightweight that you might even forget that you're wearing it. And if for some reason you decide that all of these features and adjustability isn't for you, they have a 60-day money-back guarantee, meaning you get to try Vanish holsters completely risk-free. Now, for a limited time is your chance to get a great bundle that includes one Vanish holster, plus a second holster half off, plus a free magmate with your purchase. The only catch is that this deal ends August 31st. So, to snag your deal, use my link down in the description and try Vanish holsters today. Finally, Broom says that machine guns fall into common use, which actually ended up being pretty central to the case. The defense presented data that there are over 740,000 machine guns registered under the NFA. Now, the courts actually threw out all of the guns registered to law enforcement, which I don't think is fair here, but regardless, that drops the number down to around 170,000, but still a significant number. Broom says that machine guns have been around for over a century, and he is correct, and that even though the government went after them in the 30s with the NFA, they did not actually ban possession really until 1986. And now here is the crux. He argued that because there are still legal ways to own these guns, and the fact that it was perfectly legal to own one before 1986, and that there are 170,000 of these in regular, everyday, law-abiding civilian hands, then machine guns cannot be considered unusual. Thank you, Judge Brooms. Having shot full auto, I mean, it's not something that I would rely on for self-defense, but that's not the point here. Now, the government only gave 2 historical analogues, which does not seem like very many to base a case on. One was from English common law, which prohibited riding or going armed with dangerous or unusual weapons. Broom said that Bruin already discounted this law as having no bearing on the Second Amendment, as it was about purposefully disrupting the peace with evil intentions. But the defendant in this case also wasn't charged with terrorizing people, he was charged with possession. So it has no bearing on the case. Second, the government pointed to a case from the North Carolina Supreme Court in 1824 that, quote, recognized an offense to arm oneself with dangerous and unusual weapons in such a manner as will naturally cause a terror to people, which sounds pretty much the same as that English common law. So again, no bearing here. Now, the law as it stands says nothing about intention and merely bans possession. And in fact, if someone took out a machine gun and threatened folks with it or shot up a building, well, that is an entirely different illegal act. So all of this came together for Judge Brooms to dismiss the case. Now, all that being said, the DOJ could appeal to the 10th Circuit, which has not had the worst record, but has also not had the best record. Courts have called machine guns dangerous and unusual in the past, so it could stick. They have also upheld machine gun bans in the past, which could cause it to stick. It will come down to whether or not the judges agree with the district court's interpretation of historical legal standards. And according to some folks, it will also depend on the political climate and who wins the election. Trump has been pretty vocal of his support of the Second Amendment this time around, despite his less than stellar record with this alleged Donald Trump support for the Second Amendment. Some folks think that if he were to win, the DOJ might not pursue the appeal and let the decision stand. I find this pretty unlikely myself, but maybe that's just pessimism talking. Let me know down in the comments what you think might happen here. I think common use definitely brings in an interesting component, especially with all of the politicians and news outlets claiming that Glock switches, which is part of what this case was about, and full auto ghost guns are this huge common epidemic. Because if they're really that common, then technically speaking, they are common use, which means they are creating their own defeating argument. At any rate, this will be an interesting one to follow. I am not holding my breath, but at least this presents some kind of precedent now that is on the books and might be a stepping stone going forward. All right, folks, that is it for this video. Hopefully I broke down the legalese in a way that is easy for folks to follow. Full disclaimer, I am not a lawyer. I don't know why there are some folks in the comments that think that I am a lawyer. I have never claimed to be a lawyer. I've been pretty clear about the fact that I actually used to be a psychotherapist, which is like complete opposite end of the spectrum. I guess I should be honored that some of you guys think that I sound smart enough to be a lawyer. That's pretty cool, I guess. Either way, I appreciate the compliment. Hopefully you guys think that I just sound smart like a lawyer and not scammy and shady like one. Anyways, that is it for this video, guys. You know the drill. For the algorithm things, like, share, and subscribe. If you are new here, drop a comment down below, ring the notification bell, and check your subscriptions. Make sure I am still on there. I do post multiple times a week, and YouTube doesn't always show that to people. So do all the algorithm things, check it out, and as always, thanks for tuning in, and happy shooting. But don't ask me to do math, because then I will prove that I am not smart enough to be a lawyer.